All right, we're going to call to order the Board of Supervisors work session for Tuesday, August 8th. We're meeting in the Board of Supervisors hearing room in Melody Lane. The order or deletion of any item on this agenda is subject to modification at the meeting, and any item listed is open for discussion. Please note that some attachments may be updated after the agenda was published, meaning presentation materials displayed at the meeting may be slightly different from the attached versions that appeared on the website. Members of the Cochise County Board of Supervisors will attend either in person or by remote conferencing. Members of the public may also attend this meeting via Microsoft Teams or the mobile app. Work sessions are a time for county staff to inform and discuss agenda items with the Board of Supervisors, and public comment will not be taken. We'll begin with roll call. District 1.
Crosby is here.
District 2.
I'm here.
Yeah, District 3, Antonori is here. All supervisors are present and in person. And we will begin with the introductions of who we have sitting at the table here today. Joe, why don't you start off?
Joe Casey, Deputy County Administrator.
My name is Paul Rice. I'm presenting today from Phoenix, Arizona.
All right.
It's Denise Ryden, Deputy County Attorney.
All right.
Sharon Gilman, County Administrator.
All right. And us and the board. Okay. So I guess you're going to fill in for Mr. Correa, so you could lead us off if you want to kind of introduce the topic here of discussion today. If not, I'm going to defer to Mr. Crosby.
Well, I can, but my understanding is we're just here to discuss the upcoming elections, and I am just voting in, so.
Yeah, Paul's name on the list is that's, or somebody, or was this Laura? Paul Correa on there is the, yeah, so we'll hand it up to Mr. Crosby, and he could take it from here. So,
I was made aware of the issues about voting machine test labs and engineering change orders between the primary and the general elections of 2022 by Mr. Wright in Phoenix one day, and we continue to maintain contact, and we are still in contact to this day. So what I've called this is the forbidden meeting, because the opportunity for Mr. Rice to debate with the Secretary of State has never been provided by the Secretary of State, although Mr. Rice was ready for that type of debate or interaction all the time, including today. And you remember when you sent out the invitation that we invited the Secretary of State or his representative to attend, and they declined once again. So this is the fourth time that has happened. And I believe that Mr. Rice is going to have lots of very vital information for us today.
all right, Mr. Rice, we'll turn it over to you. You have a slideshow.
So actually, can I start off?
Oh, I'm sorry, Joe. I'm
So,
sorry. I didn't know.
Can you put that diagram back up? So this is just a diagram we put together with the elections department to try to make it clear who the people are that we're talking about, because Mr. Rice is going to have a lot of detail and just kind of set some groundwork so we're all on the same page so we understand what the process in general is. Okay, so in the top left corner, you have the EAC, or Election Assistance Commission. They're responsible for accrediting a test lab. In this case, the VSTL, the voting system test labs, they do the actual testing of the election equipment. Okay, and so once that testing is done, they'll send the report back up to the EAC. It's very convoluted, that's why I want to kind of explain it.
Yeah.
It goes back up to the EAC, who would then issue the accreditation on that equipment. Okay, which then goes over, in this case, we're talking about ES&S. So that's our vendor that we use at Cochise County at this time.
No. Laura, can you blow that up? And is that showing on?
That'll be
Yeah,
part of the permanent record of the meeting.
Is there a presentation mode or is that a PDF file? Oh, it's a PDF file. I thought it might have been PowerPoint.
Yeah.
And if you went to, can you do the presentation mode on PDF files?
Hold up one more time. Getting better.
Okay. So back to the EAC accredits the lab.
Right.
The lab then does the test. Once they finish testing the equipment, they do what's called a trusted hash. That trusted hash is stored. What a hash is it's, without going too complicated. It's basically an algorithm. At the end, it gives you a number of a math problem. If anything changes in the equipment, that math problem would change, and that hash would change. And so later on in the process, the vendor, ES&S, anytime they do any upgrades, install equipment, or anything like that,
Change that number.
They do change that number.
Okay.
And so they'd have to run a new hash to compare against the trusted hash that was done at the VSTL. Okay. That's just overall the general players and how the process works as a whole.
Okay.
All right.
Good?
Yep.
All right, good. We'll give it to you, Mr. Wright. We allotted you about 30 minutes, so we may give you some latitude since the Secretary of State didn't show up.
I thought it was an hour.
No, 30, the meeting was an hour. The meeting was an hour. It was 30 minutes each. But we'll give you some latitude. But if you could, we had,
So that's okay. That's all right. We'll go through this quickly.
yeah.
Not too quick, but there's more information here that I'm going to be able to speak to in detail. But the reason the presentation is so long is because you'll have it afterwards. And the first thing I'll say is I want to thank you for the opportunity to present here. That's the first thing. You know, as Tom mentioned, we tried to present in we did present in 22. That conversation didn't go forward. And this is really kind of a continuation of that, and we have 3 years hindsight also, although several things that are really important haven't really changed. So I think with that, I'm going to get into this then. So should this be able to advance?
What's he supposed to plan that, Joe?
Then he's going the right way.
He's going the right way?
Is it on? Thank you. So the format of what I've done here is to ask the question, present the facts, conduct an analysis, and reach a conclusion. And of course, that's my conclusion. So this is a biased presentation, but I really want to stress the importance to me and to my colleagues in 22 was always to get to the truth. And I won't challenge you on anything that has to do with the technical side of things, as far as what's done underneath the hood. This is really about the statutes and about the electronic voting machines in the Constitution, those 3 things. So why are we here? What this discussion is about is our Constitution, our election laws, protecting our sacred vote, exercising our First Amendment rights, and the electronic voting machine's primary count. This is not about a hand count audit after the election has taken place. This is about using the machine as primary counters, tabulators of our elections. What this is not about is election fraud. So this is not about fraud. This is about the law and about the Constitution and how the electronic voting machines, what I'll try to show today is that those have been violated, the statutes and the Constitution. This is not about partisan politics. It should not be about Republican versus Democrat, hand count, post-election audits, and it's not about logic and accuracy, which is completely outside the scope of what we'll talk about here today. So that was my picture, actually. I took that in North Phoenix. Most of these are my pictures that I have here. 3 primary questions are addressed. Are electronic voting machines legal in the state of Arizona? Are county boards of supervisors obligated to utilize electronic voting machines in their elections? And does Arizona law require county boards of supervisors to certify their county elections? I am not an attorney. I'm a citizen. I'm an Arizona citizen. Anybody could have done this. I just spent the last 3.5 years of my life looking at this and reviewing this. And these are the 3 primary questions that I was hoping, to address today that are really important. Several of these are already being adjudicated in the courts. Warren Peterson's case, of course, addresses some things that were put in the election procedure manual. The whole issue of the machines being used, Ron Gould and Mohadi put a case out on that. So I will say that some of these are not really, they're still kind of in limbo right now, to be honest. If I go too fast, please stop me. If there's a question or something, because I didn't prepare for 30 minutes, so I'm going to go through here. This is actually in Prescott Valley. That's a 9/11 celebration on the county grounds. Are electronic voting machines legal in the state of Arizona? So there's 4 sections: HAVA, EAC, VSTL, and VDSGs. Okay, the first one is the Help America Vote Act. That started in 2002. October 29th, actually, it was signed into law. That's what gave birth to the electronic voting machines in the country. Let's go forward from there. Okay. So as you read through this, and this is available on the website, right, Frank?
Yep.
Okay. So anybody can go on the Cochise County website and read all of this in detail. This gives an outline of what HAVA is, the reason it was put into place, and the state, really the Constitution gives the states the rights to govern, to legislate and administer those elections. And this is taken directly out of HAVA. I have read HAVA a number of times, and it establishes here that it was put in place to provide money to states, lots of money go to the states for our electronic voting machines, lots of money. And the states have to use those voting machines to get those federal funds. It also established the Federal Election Commission, or excuse me, the Election Assistance Commission, which replaced the Federal Elections Commission, and it established minimum election standards for the states to follow. So basically, the laws were put in place to create a more uniform way of administering elections. That's the purpose of it. A couple important points here as far as signatures on documents. The fact that the original HAVA required appointment by the President of the United States to the 4 members of the board, and the Speaker of the House, Senate Majority Leader, and the minority leaders were involved in that, kind of says this is kind of important as far as who's signing what documents. And of course, on the right-hand side, it has to do with the fact that the electronic voting machines were super important to the passage of HAVA. The EAC, the HAVA law ushered in the formation of the EAC, which creates the detailed election procedures that states must follow. Each state makes its own decision regarding HAVA, regarding the minimum standards or the maximum that they want to follow, because as I said, the Constitution gives the states the rights to do that, or actually makes it that the federal government cannot. HAVA is federal law. State adoption of HAVA becomes state law. Many functions transition from the FEC to the EAC, and one of the most important functions of the EAC is to accredit the private companies that certify electronic voting machines. Those electronic voting machines are reviewed and certified by the VSTLs, which are private companies. And it's the job of the EAC to accredit those companies because really when it comes to safeguarding the privacy of our vote, the integrity of our vote that runs through those machines, it's really the voting system testing lab that does that. So the accreditation process is really super important to basically running our elections. The EAC makes the final decision as to what company becomes a VSTL. There are only 2 in recent election cycles. SLI Compliance and ProVNV both are involved in your machines. The ES&S generally puts out the new software upgrades. There are modifications, which we're going to get to here shortly, which are certified and assigned an ECO number and certified by ProVNV. They do that for some of the software for ES&S. We won't get into this. This is probably more of Joe's areas of VVSGs, which is the technical component, the standards that are met for the machine testing. This is a list of the commission chairs, and my colleague, Brian Steiner, did a significant research. These are really hard to find anywhere on the internet, but these are the commissioner chairs in place. I don't have anybody from 23 onward, but you can see they generally serve 1-year terms. And these are the manuals under the EAC governance part of it that effectively promulgate the law. Because when HAVA created the EAC, effectively they gave the EAC powers to write the detailed procedures as long as they were congruent or in alignment with HAVA. Similar to the EPM in Arizona, where it's written by the Secretary of State, the legislature writes the laws, and then the EPM is created by the Secretary of State. The legislature gives them that authority. It's very, very similar here. So you have the voting system test laboratory manual, you have the certification manual, and you have the voting system guidelines. It's the voting system test laboratory manual that we'll talk about today. So what does the Arizona Constitution and the statutes say? The Arizona Constitution says highest number of votes received as determinative of vote person elected in all elections held by the people in this state. The person or persons receiving the highest number of legal votes shall be declared. At a statutory level, really, the guts of what we've talked about in 22 as well as today has to do with this statute. Machines or devices used at any election for federal, state, or county offices may be certified for use in the state and may only be used in the state if they comply with the Help America Vote Act of 2002. And if those machines or devices have been tested and approved by a laboratory that is accredited pursuant to the Help America Vote Act of 2002. This is the gist, really, of the law that we've always, discussed, is are the machines certified by an accredited lab? Technically, the EAC certifies them, but are the labs accredited to do the certification and the due diligence that the EAC actually, they sign up certificates on it. But that goes from the VSTL to the EAC. Accreditation and certification are two different things. Accreditation is to recognize or vouch as conforming with the standard, to consider as recognized as outstanding. So accreditation means a very high level, a very high threshold of meeting certain standards. The VSTL must be accredited by the EAC to test. Certification is an attestation that those accreditation standards have been met. So when the EAC certifies the VSTLs that they have done work that's true and that those machines have actually passed certain tests, they'll certify that they believe that that work was done to meet the standards of attestation. So once a company is selected to be a VSTL, that company must initially be accredited and reaccredited by the EAC after every 2 years. This is one of the major points. The requirement is outlined in version 2.0 of VSTL manual, which is published by the EAC. The accreditation is evidenced by a certificate of accreditation issued by the EAC to the VSTL. So the certifications, and they're called certification of conformance, are the certifications that are issued for specific software upgrades. So I think you guys went to 6.3.0.0 not too long ago. You were at 6.0.4.0 3 years ago. I don't know if there was something in between there or not, but there's a certificate of conformance that's issued by the EAC that says, yes, they meet the minimum standards that are required under the voting system guidelines, and the work was done by the voting system testing labs. But the accreditation process is not only legally required, it's vital to maintain the integrity of our electronic voting machines. These machines have been deemed critical infrastructure to safeguard elections and national security. This vetting process includes an assessment of, and these are the major things of why accreditation is so important, because the next version of this VSTL manual, which this one was published in 2015, the next version that came out was right after the 22 elections, 3.0 VSTL manual. And I will show you that they dropped the 2-year minimum accreditation completely. There is no accreditation requirement now to be maintained. In fact, I don't know of a, and again, I'm just the guy who's done a lot of research on this. If there is a, for example, Pro V&V certificate that's been issued since 2015, I'd like to see that. The last one I think for SLA compliance was 2021. And even that one that went into 21 was 3 years. The certificate said for 3 years, it's only good for 2 years, according to the 2.0 manual. The 3.0 manual was watered down and it dropped that 2-year requirement. It doesn't exist anymore. But that accreditation process has to deal with technical competency, financial stability, so it's not just a technical component. Records retention and the possibility of conflicts of interest and foreign influence.
Mr. Rice,
Yeah.
with regard to the 2-year period, did anything in the law that Congress passed change regarding the 2-year period of accreditation?
Well, technically, the law is what the EAC says it is. There's nothing in habit that says about the duration of the accreditation period.
So Congress knew.
NIST, which is a very, there's people who own test labs understand NIST, which is a critical component of the technical side of things, I think has a 2-year accreditation period. But industry standards for the gaming industry, probably at least 2 years, maybe even more frequent. Our elections, and I'll show you the slide, they dropped that requirement out of the 3.0 manual completely. Okay, this slide, basically, I wanted to back up what I'm saying just with some slides out of the EAC website. So you can see this, your own purview. The same with this one. The participation, this is important, the participation of each state varies depending on whether they want to adopt all of HABA or only a little of HABA. Arizona codified quite a bit of HABA, requiring us to use VSTL. So we use the voting system testing labs, which are private, to make sure that the machines that are deployed in the counties, like you guys just bought you spent a couple $100,000, $300,000 on two new machines. Those machines have to be certified by EAC, and the work done is by probably, I would think, SLI compliance in this case. But all of the rules that surround that are state law because you have adopted what was federal into state law, excuse me. Okay, this is out of the website. This is where ProVNV is and SLI compliance. Interesting, they've removed the address. They used to be out of Colorado. I think they still are, but I'm not sure why they took that away. Okay, so here's the detailed requirements on certificate of accreditation. Under 2.0 manual, which was in effect for the 18 election, the 20 election, and the 22 election. What's in question now is the 24 and the 26 election, and I'll show you why. If you notice, number 3.6.1.3. So again, this is written by the EAC, requirements of voting system testing labs, which is promulgated law under HABA. The effective date of the certification, which shall not exceed a period of 2 years. There it is. A grant of expiration is valid for a period not to exceed 2 years. And I also have a letter from one of the technical directors of the EAC from 2021 that'll reassert that. A VSTL's accreditation expires on the date annotated on the certificate of accreditation. Okay, and it goes on to explain just kind of what I talked about there. Here's the 3.0. Name of the VSTL, scope, effective date, no expiration. Okay, so here is the original SLI compliance certificate of accreditation that was issued on January 10th of 2018. According to the law, it has to be signed by the commissioner, the chair of the commission, which was Matthew Matterson. And again, you can go through this on your own afterwards. And I apologize for speaking so fast, but I didn't allow this for 30 minutes. According to the 2.0 manual, accreditation shall not exceed 2 years. On this certificate, it's a 3-year window. That makes this is a binding contract is what this is between the people and the government. The next one was issued in 2021 because they gave a 3-year. And we won't go into all the nuances with what happened with COVID and all that stuff. But in any event, this was issued in 2021. Now, they make a note here about the original accreditation, and I have the certificates that were issued in 07 and 09. So what they did here was the EAC is deferred to U.S. Code 52, Section 20971, saying that, and I'll get to that it doesn't need to be accredited every 2 years because that part of the law says it's only goes away if it's revoked. What this section of the law says is it contains the specific circumstances under which a certificate that is legally accredited can be revoked. In other words, if you're in the middle of an accreditation period of 2 years, this part of the law says these are the conditions under which that accreditation can be revoked. It has nothing to do with the expiration, which is written in the VSTL manual. Those are two separate things, and they've convoluted. There's an error there. There's a typo. It says, why not just post the original accreditation issued on 2/28/26? That's 07, by the way, not 27. Okay. I think I'll skip this one. This one was issued. It's been pulled off the website because they actually had a ProVNV accreditation date on this certificate, and they realized they had the wrong dates on it. Okay, so here's when I pulled it back from 2009. As you can see, this is from 2009, 2-year period, July 16, 2011, signed by the chairman, as it should be. The next one in 2000, whoops. Let me go back. Here's 2007 to 2009, excuse me. Okay, that one was signed by the executive director, so I guess they can sign for each other if they want. 2-year expiration, which is what it should be. I should have reversed those slides. The next one 7/16/09, signed by the chairman properly. Again, 2-year expiration. So somewhere along the lines, they decided that they didn't need 2 years anymore. And this is the certificate of conformance that I was referring to. This is not about accreditation. This is about the particular software version that was just uploaded. So this is the one that was issued, Joe, for 6040. This was issued May 3rd, 2019. That date might be familiar. That would be within the 2-year window of the 2018 certificate of accreditation that was issued, but it wasn't signed by the commission, by the chairman. It was signed by the executive director. And what I'll get into shortly, if I have time, is the modifications, because all the modifications that occur to the software from the date of issuance of this software version have to go through a state certification process at the Secretary of State's office. And all of those changes, whether they're security enhancements, they could be bug fixes, they could be very immaterial de minimis changes like, non-consequential changes. They all have to be approved, just like a new software like this upgrade by the voting system testing. Okay, so what we've been told is that they can rely on 52 U.S. code to say that they can have the voting system testing labs accredited forever. Okay, here's the section of the code right here. Okay, there's 3 pages here. I don't have time to go through them, but as you can see, here's the key language. Approval by commission required for revocation. The accreditation of a laboratory for purposes of this section may not be revoked unless the revocation is approved by vote of the commission. Again, this has to do with revoking the VSTL's accreditation or their ability to certify during an already valid accreditation period, which was 2 years. Has nothing to do with the fact that they can extend it forever. Okay. Here's a letter from Jerome Lobato, VSTL certification director, written on SLI compliance as accreditation. This is coming directly from the EAST. Look at the date of that, January 27, 2021. Expiration and renewal of accreditation. Now, this is written by Jerome. He's the director of certification. A grant of accreditation is valid for a period not to exceed 2 years. So I'll ask the question, U.S. Code 52-20971, that was promulgated in HAVA, which was 2002. How can you have that section of the law be in there and also have a 2-year expiration of accreditation written by the VSTL? Those are conflicting. This law right here has been in existence since 2002. And if that's the case, you can't have any, you can't have, if it really means that you can revoke it whenever they want, this would mean nothing. But the VSTL is the one that designates how long of accreditation period they have, which is 2 years, for the reasons we talked about. Super important things, like conflicts of interest, like financial stability, like technical competence, all of those things. This is about state certification. This is the process, and this is in the law, and it was in the EPM manual. Secretary of State pulled there was 10 pages relating to this process, so this is at the state level, that pertained to the detailed procedures relating to the state certification of all the machines that go throughout the state. And that has to do with Dominion, Unison, and Prescott, and also the other 13 counties that have SLI compliance. And this goes through the process by which there's a committee. It's all, the committee notes are all on the website. And they have the manufacturers come in and test or show them, not test, but show them the changes. And then they run some tests there. And if their material changes, they'll run the tests. Okay. So this goes through all of those processes, those procedures. These are no longer in the EPM. They were pulled out with the 23 manual. I don't know why.
The 23 manual, though, that I'm going to refer to our attorney on this, that's the one that got kicked back with the appellate court that said that is no longer valid.
21.
Which one?
21. That was
20. I thought the 23 was included in that. No?
It was in, I don't know, because the 21 was really not
They
published.
said that, I think the court ruled that it was, the last valid one was the 2019.
Well, the 23 is on the website. And
Well,
it's,
that doesn't mean it's valid.
pages well, they're gone. So if what you're saying is true, then the 2019 is still in effect, and the 25
That's what I thought. I thought the
Yeah.
court had ruled that it reverted back to 2019 was the last one that was done valid
Of the EPM.
of the EPM. Yeah, that's what I thought.
So that would mean, well, those, all right, well, then this should all be valid. Either way, I don't know why you would pull it out, because these are important.
Yeah.
Because this is the here's
Yeah, well,
the
we
statute.
could make assumptions of why it was pulled out.
Yeah, here's the statute. This is section A. I
Yeah.
forgot to put A in there. Okay, this is the statute. This is the EPM.
Oh, Ms. Savant, did you have a comment?
Just a comment. So the EPM for 2023 is valid.
It is.
It is valid.
Okay.
Yes.
Okay.
Thank you.
Mr. Chair, what did you say? We can make assumptions about why the pages were pulled? What did you mean by that?
Well, I mean, we have a elected Secretary of State who gets to make certain decisions regarding election procedures, not necessarily election law, because the legislature does the law, and then he's supposed to build the election procedures manual based on the statutes that are provided in various titles, which mostly Title 16, right? So, and then he puts the election procedure manual out, and then the governor and the attorney general validate it, right? So that those are the three people that sign it. I'm just
I mean, they're
pointing
having,
out the obvious that they're clearly of a,
there's separation of powers
particular-
issues, I think, personally, but I'm
yeah,
not an
but there's
attorney
a
again.
political,
Right. And I'm not here to judge. I'm just here to present the information
Yeah.
as it is.
instead of somebody from the legislature signing off on it to verify that the manual complies with what the legislature wanted, you have the executive branch basically carte blanche signing off on the election procedure. Right? And they're all one particular party, and then the legislature is of another. Majority of the legislature is of another political party. You would think you would require both the executive and the legislative branch to sign off on that. Because the attorney general is part of the executive branch, right?
So
A lot
I
of people get
believe-
confused. They think she's judiciary. She's not. She's
I
executive.
believe it was Warren Peterson's case that challenged, the addition of some things in the EPM by the Secretary of State relating to the mandate to certify.
And he went beyond the statute.
Well, that's what they
Yeah.
interpreted, that he pulled, So the Secretary of State has tremendous power on this stuff, to pull stuff out or put stuff in. Okay, important points. The 2019 elections procedure dedicated 10 pages in chapter, now this is what I'm talking about, the voting chip, to the electronic voting machine, new certification and modification procedures. Effective with 2023, these are gone. Okay. The explanation, which is part of the changes, is a published listing of all the things that were removed. The explanation was provided at the last item was part of the election equipment certification chapter, and this is directly in the Secretary of State website, was removed and has been added to the Help America Vote Act of 2002 handbook. Now, again, if I'm mistaken on anything I'm presenting today, I welcome a rebuttal or to correct me. I'm not here, to claim to be the world's expert on this stuff, but I can't find anywhere, including using AI, anywhere, Help America Vote Act of 2002 handbook. I don't know what that is, but it's not in the EPM anymore. As outlined in the EPM, an engineering change order is a change to a previously EAC certified voting systems hardware, documentation, or data. These modifications used to be made available to the Secretary of State website. There was a listing of all the ECOs in there. I still have it. Vanished. It does not exist anymore. And it had when there's an ECO that's put in place, it's assigned a 5-digit number. That ECO should be published, I would think, for public review.
It's on the EAC site now. I was looking at it a couple days ago. I'll share that link with you.
Oh, yeah, I'd love to see that.
Yeah.
Yeah, because it disappeared for quite a long time. I mean, there's a listing of all the machines that are being used, and there's a listing of all the softwares, but I couldn't find the ECO.
Yeah, there's a change.
And so when I did a public records request with the EAC, and I got a response. I'll show that to you. Because I asked for it, and I've been asking for it since 2022. Because the EAC doesn't know what changes have been approved by each state. They don't track 50 states. All states adopt different things. So those those change orders that have to go through a process of the review, meeting with the representative in, the Capitol or wherever, and then the Secretary of State signing off. The commission, the committee, the 3-person committee makes a recommendation. That whole process was part of the EPM, which is underneath that statute. Those change orders are then deployed in the counties. There used to be a document that showed what all those were. I requested that again. I've requested it 3 or 4 times since 2022. They've never answered me. The most recent one, they said, just go to the AC website. The AC does not track what each state, so the state has to maintain records on exactly what engineering changes.
What would you expect our county elections director to have in the way of records with regard to engineering change orders?
I mean,
Here she comes. She's coming.
She doesn't handle the engineering change orders. Those are done. Okay, Ms. Bond, I'll let you.
Okay, one more comment. So in terms of the engineering change orders, they, as Joe stated, they're on the Elections Assistance Commission, and it is by state. So you can go on that website. It's selected by Arizona. You can go down and see the all the change orders on there. And then for Arizona, Scott Jarrett, the elections director for Maricopa County, is part of that commission, as well as Ray Lee Richards, who is Navajo County.
well, I know they list the software versions by state, but I'm not looking for the software
Right,
versions.
the ECO's under the
Well,
ECO.
maybe the fellow that responds to these public records requests is mistaken, because I will show you. Here's the letter, June 9th. Mr. Rice, this letter acknowledges the U.S. Assistance Commission's receipt of your Freedom of Information Act. The EAC's records that are responsive to your request are publicly available on the EAC website. And it was interesting that the representative, he felt the need to do this. The Freedom of Information Act does not require federal agencies to answer questions, render opinions, or provide subjective evaluations. However, the EAC does not track where engineering change orders have been deployed on a state level. Nor does the EAC track any information on what systems or modifications each state has adopted beyond the EAC's system level map, which is publicly available on the EAC website. So I guess we should look into that, because that's not what I just heard from us. Okay, so here's a listing chronologically of all of my records requests. I did have detailed communications with the attorney there back in 22, back and forth. Could never get a response. I responded again so Supervisor Crosby, I think, made that public, right? You submitted a request,
Yeah, I'm
Tom?
looking at it right now.
Yep. An affidavit was provided by myself in 23 saying that nothing had been requested. And if they don't have them, all they need to say is, I don't have them, instead of, ignoring me. Over a year after the original, I requested it again in 23. And then April, I requested again in 25. They told me to go check with the AC, so I did. And that's the letter that I just requested another one June 11th. Still no request or response. I'm in the queue there. Okay. So I really regret having to go through that so quickly. I'm really glad I put it all in writing, though, for future follow-up. How much time frame?
You got about, well, you're over, but we'll give you another 10 minutes.
Okay.
Can you wrap it up in 10?
Yeah, I'll go through fast. This is more, okay, again, this is from my research. I'm bringing these issues up. I have to applaud this board, because any board could be doing this. I've presented in 3 or 4 different counties and given detailed information over the last 2 years. Every other county has foregone really going into this. Every county could do this, just out of curiosity, because there have been a lot of public concern about the security of our elections. And again, I'm not challenging you, Joe, on the technical aspect of things. I could bring in, if you'd like, one of the world's best that testified in Georgia as an expert witness. He'd be happy to come here if you guys want to get into the technical side of this. Our county boards of supervisors obligated to use electronic voting machines. Now, what I did was I went through, and I'm going to summarize this really quickly. I went through all Title 16, Chapter 4 voting equipment, Articles 1, 4, and 10, and I've cited. I have a detailed, and I can give the board any detailed supporting documentation for this PowerPoint. For example, this is about a 10 or 15 page document of all the statutes, and I've highlighted to support what I present here. Because it really does come down to the law, right? To the statutes and interpretation of the law. And I'll be honest, I don't think in Supervisor Gould's case, the judge really addressed the issue because he said Ron didn't have the right to bring it to the court in his individual capacity. That was a board, it should have been a board thing. So he really didn't address this issue. There are 2 statutes from Article 1 that I cited, 3 from 10, and then every statute under Article 4. And I should read this. To demonstrate there's no Arizona statutory requirement that state, county, and local authorities utilize EVMs or electronic voting machines, tabulators, in Arizona, a detailed analysis of ARS reveals that county board supervisors, in fact, have complete discretion with regards to the use of the equipment used in the conduct of their elections. It's noteworthy to mention that while the requirement can be found in Chapter 4, Conduct of Elections, mandating the use of electronic voting machines, the entire chapter is written in a manner that assumes this voting equipment is in place. Policy, whether obligatory or non-obligatory, are geared toward an election system based on the use of EVMs. In other words, the whole statutes are set up so that it assumes that voting machines are being used. It doesn't talk about hand counts. But here's some observations. And again, this is just for anybody that's curious about the law or wants to, and it really should be adjudicated in a courtroom. I'm just trying to bring up what I've seen. The word shall, which is mandatory, and that was actually just came out in a case out of Georgia, a judge, that this issue came up. It is mandatory. It's used 160 times in these statutes by the legislature. It's not optional. The word may, permissive, discretionary, 20 times. Given the term shall is used 8 times as the word may, it's clear that they were not bashful. They were very deliberate in mandating most election procedures. However, there is not one instance, and if someone can find it, I'd love you to show it to them, where the use of the word shall is associated with the use of the EVMs. In fact, if you look at 16443, it says exactly the opposite. When given the opportunity to use the word shall, the legislature chose the word may. At all state, county, city, and town elections, agricultural improvement district elections, and primary elections, ballots or votes may be cast, recorded, and counted by voting or marking devices and voting tabulating devices as provided in this article. And my conclusion is that Chapter 4 provides strong evidence that the Arizona legislature intended the use of the EVMs to be entirely discretionary to the boards. This is supported in the language, specifically the decision to use the word may as opposed to shall when referencing the use of the equipment. And therefore, any claim that it's mandatory, I don't understand how you make that argument. Okay. And the last one, maybe I can come in under time here for him, has to do with certification versus canvassing. This is a big one. Okay. Question. What do these terms really mean? Canvassing, an election, and certifying are the same thing. Question. Canvassing an election and certifying an election are separate and distinct duties. Canvassing is required under the IRS. Certification is part of the canvassing process. There it is ministerial and required by default. Canvassing and certifying are individually required under statute, or canvassing is required under Arizona statute. Certifying is not required. I contend it's the last one that's true. So let's go to Black Law Dictionary, one of the highest authorities in definitions in the law. Canvassing, the act of examining and counting the returns of votes cast at a public election. The Merriam-Webster Dictionary, in 1928, to examine returns of, to examine, to search, to scrutinize. Close inspection. The more recent version, to examine in detail, specifically to examine officially for authenticity. What does the EAC say about canvassing? The canvass is a culmination of all the data generated during an election cycle. Okay, and if you read through this, it means counting and making sure that all of the ballots from the precincts or the voting centers are in, that they've all been counted and accounted for. What does certification define? I couldn't find it in Black Law Dictionary. To testify in writing, to test authoritatively, to make a declaration, to attest as being true or represented. These are clearly two distinct actions. They are not the same thing. Because as a board, And I'm going to argue under your oath of office, you do not have an obligation to certify. In fact, if you become aware of information that there's been a violation of the statutes or the law has been broken, it's your oath of office, under your oath of office, and duty and obligation to not certify. In fact, all the other counties that just certified actually broke their oath of office, because most of them had, what I saw is particularly in Mojave and Prescott, there were serious concerns about certifying the election. The election certification refers, and this is from the EAC, refers to the process of election officials attesting that the tabulation and canvassing of the election are complete and accurate, and that the election results are true and accurate. Doesn't matter about the count. Is the count true and accurate? And when you attest to the state and the governor signs to Washington, D.C., you're making an attestation under your oath of office. I just cited the Arizona Constitution here, Article 5 and ARS, to show even our government recognizes there's a distinction between the two of them. Canvassing and then issuing certificates. I don't want to repeat myself here. So I went into the statutes as well. What did I do? I wrote here, okay, canvassing and certifying are independent actions. Both are required to complete the election process. Canvassing is absolutely required, and I'll show under the statutes. There's no question that, and I think, didn't they short the process, the time frame from the election to when you have to canvass the election?
10 days, right?
I think the last election, it was shortened from 22, wasn't it?
How many days? The change in the law.
Yeah, there was a change in the law, was there not? So you even have less time. The legislature
10 days, right? Yeah, 10 days.
Has given you less time than there was before. So if you become aware of fraud or, for example, what was of concern on the electronic voting machines, you have less time to remedy that. In fact, it's impossible to remedy it before, and I'm going to show what the problem is there. So by definition, these terms should not be synonymous, and they're not synonymous, and they should not be used interchangeably. Here's the statutes, and I'm not going to read all this. Everything in yellow is the word canvass. Okay. The word certificate is used to reference the issue of certificates. Okay. There is nowhere where it says the board shall certify. And please, everyone, check me on this. If I've missed it, I won't have time to go over it. That was on the Abraham Lincoln. That's an F-18.
We've had this discussion on the DS-4, but there's
nothing like being on the deck of the Abraham Lincoln aircraft carrier and being 100 feet from an F-18 taking off.
Yeah.
Okay, so there is reference to issuing certificates, okay, in the statute here. And this is up, again, this should be adjudicated in the courts. I forget which one it is. Okay, here we go. Declaration of, okay, issuance of certificates. So in a way, they're saying you have to issue a certificate. It doesn't say you must certify, but you have to issue a certificate by a certain deadline, okay? All right? What I would say about that, I don't think there is. I don't think you have to. If you can find the word shall, why wouldn't they have written shall certify? It's kind of like the machines. They talk about the machines and all the stuff about the electronic voting machines, but I can't find one sentence where it says shall use the electronic voting machines. D-Day. Okay. All right, this is the part, and this is the last part, Frank, so I'll wrap it up. Would Arizona law violate the people's constitutional rights if it required a county supervisor to certify its election results, despite that supervisor having knowledge of a potential material illegality involved in that election? The oath of office is under ARS 38231. And you take that oath of office and you swear allegiance to the Constitution, the state, the federal Constitution, and the constituents that you represent. That oath requires that you support the Constitution, the laws of the Constitution of the United States of Arizona, bearing true faith and allegiance to the same. Safeguarding our elections is the most sacred act a county supervisor will perform under that oath. Each county board has the duty to oversee those charged with administering the people's elections to ensure every citizen's vote is accounted for and properly reported. Therefore, a supervisor acting in good faith, and I believe what happened in 22 was all in good faith, becomes, of course, we were not allowed to continue the discussion because the judge said otherwise. who becomes aware of fraud, malfeasance, or any other potential election illegality cannot certify that election while also honoring the oath of office. Alternatively, a supervisor who certifies an election with knowledge of these potential offenses violates the sacred oath, bringing offense to the Constitution, abandoning the constituency that he or she was elected to represent. That's what happened in 2022, from my perspective. Officials and county attorneys perpetuate the idea of the county supervisor acting in good faith while expressing a legitimate concern about the legality of his or her county election must first certify and then file suit in the judiciary 5 days after state certification. This is one of the reasons Judge Timmer threw our case out, because we didn't do it quick enough. This mandate is an assault on the people's constitutional right to free and fair elections. The Arizona legislature must act and implement a mechanism by which a valid and material election concern can be addressed and resolved prior to certification, not after. Conclusion. A judicial order, Arizona statute, or election procedure mandate that requires a supervisor to certify an election without a process available to first address and resolve concern is forcing that supervisor to violate his or her oath of office and constitutional duty to fairly represent the people. Now, I'm not talking about de minimis or frivolous concerns. That's not what I'm talking about. Legitimate concerns, because I think that is violating everyone's rights when that happens. And that's an actual picture I took right there out of the deck. That's a real rainbow. I took that one. That is my picture. Abraham Lincoln right there. That's D-Day, as I mentioned. I didn't take that picture.
So to sum up, I got your points, and I've had this discussion with my colleagues before, and I call the question of the definition, as we kind of stated with the special election that we just completed. Right? There's a significant difference between canvassing and certifying. That's the canvassing is just to meet and review and go over the election. Right, that's the way I see it. I know you're in a discussion with that on that in your case. I don't want to put you on the spot, but that's the way I interpret it. So I agree with what he's saying with regard to the separate definitions between canvass and certifying. Certifying is saying that we canvassed and analyzed the data, and we hereby believe that this was conducted fair and proper and without error or issue. So we're going to certify
To the best of the county's ability.
to the best of our ability, and we're going to certify it. So, to say certification is ministerial and you have to certify, it's your job whether you like it or not, I think is a stretch by the courts, which I said was what I thought was wrong with the Pima County judge's decision regarding that case. I mean, you technically met the canvas, so you met the statutory requirement, the way I saw it. But that was
There was a case that was put out by, and again, I could have prepared because I followed all the cases where the judge, and maybe it was the Warren Peterson filing where the Secretary of State put the mandate in there that the counties had to certify.
Yeah, and they took
and
it out.
secondly said, if you don't, the state's moving forward without you.
Right.
And the judge shot down both.
Yeah, I
Take them out.
I saw
He's not saying it's true or false. What he's saying is that can't be decided by the Secretary of State. So what he's saying is this needs to be adjudicated.
What needs to be done is again, this is we're limited because we are a political subdivision of the state, right? So counties are political subdivisions. The legislature has to define a cure for that process. That's the problem. There is no cure in statute. It just says you will do this and you will do that. Well, what if we find a problem here? What is the cure for that problem? What is the process to execute that problem? And that's not in there. It's not in the statute. So if
It is as if the legislature is saying, there's never going to be a problem with
Correct.
elections. We don't have to worry about it.
So let's and there have been, and we've seen some of the cases that have gone on less. I mean, the big election fraud in Georgia that was going down, the one in Alabama, which was Republicans actually was guilty on that one. That was a Republican election fraud. One in Georgia was a Democrats committing election fraud. Both parties do it, right? They people find a way to cheat to win. I mean, it's an inherent sometimes flaw that people have. They try to do that. Okay, and we had the case in here with the alleged forging of signatures to get on the ballot. You have all these cases where people will find a way. They think they can get away with it. They get caught, and then things happen. Well, I'm just saying, what if we have an election in the future and we see something, Ms. Savant comes to us and says, oh, there's something weird here. You know, we had this precinct and there's 93 people registered to vote in this precinct and 107 people voted, which I'm just saying as an example, right? So we canvassed, we met, we found something funny. Now we say, okay, wait a minute, something's wrong. We got to pump the brakes and we have to look at, we have to pump the brakes and we have to look at all the other precincts now because we can't validate, right? So now are we going to get in trouble because we're 8 days in, we're 2 days away from the deadline, and if we don't canvass/certify and send the report up to the state, are all of us going to get indicted by the Attorney General now? I mean, that's the point I'm trying to make. There's no cure though. So you're basically, in your case, forced to comply, especially if a judge steps in and says, you will. You know, then that gives them the legal basis, and that's what.
Well, it's interesting that Judge McGinley did not use the word certify in his order.
Yeah, I know, and again, but
He used the word canvass, which technically I can't find a provision that says under what specific procedures qualifies that you canvass. I think it's when the election director or the representative that's in charge of your elections comes to you and they present you the information, say, hey, this is the votes from all the precincts. And here it is, and it's to the best of our ability. This is all of it. And you say, okay, I think you just canvassed. Because you're taking their attestation, they've done their job. You look it over, you say, oh, all the counties are here. Everything's in here. Everything's totally tallied. I would contend that you have canvassed. And you guys actually did that. And the judge didn't really say certify in his order. He said canvass.
But again, the lack of a cure is the problem that I think led to the problem that our colleague here is facing, because he and Ms. Judd both thought they saw anomalies, and all they wanted to do was pause and pump the brakes, and that was what created that problem. There's no mechanism for that. There's no cure. There's no criteria for what a pause and pump the brakes moment is. What do we have to find? What abnormality do you have to find before you can say, okay, this is out of whack. We have to stop, pump the brakes, and go look? Is it just the hand count was off on this one machine, and then we recounted it was good, and then we just keep going? Or do we say, well, why was it off in the first place, and we stop? Well, that's what I'm getting at. There's no definition of a problem. There's no cure.
I think it comes down if it's reasonable. If a person would come to a reasonable conclusion that you have concern, and I understand.
I'm with you. The problem is
the legislature shortened the time.
Yeah,
they've shortened the time frame you have to make those. So if you run across anomalies now, you've got less time.
But what you're implying is discretion to the board, right? So we get to determine through that reasonably. So we say it's reasonable, but the problem is we have attorneys general and judges that may disagree with us and then use the judicial gavel to beat us down with it or say otherwise, which is the case, I would argue, that happened with Ms. Judd and Mr. Crosby, right? So they thought they saw something. They said, hey, let's just hang on a minute and let's look at this. And they were told, no, you will, he wanted to have additional work sessions. He wanted to review things. And they were told, no, you have to have, this is a deadline, or we're not going to count Juan Ciscomani's votes, and that was the threat. I don't know if you.
Well, this board, and I know we don't want to go back in time, but this board was prepared to certify on the 28th. That ability was prevented. They were prevented from doing that. We were prevented from speaking. And had not this chair misagendized that meeting, that would have taken place. And there was a good chance maybe they would have certified on the 28th.
Yeah.
But they decided to wait till December 2nd. A judge intervened on December 1st. Case closed. Done. So I'm saying that I don't disagree that, yes, there is not a process by which you have under the law to resolve. Well, what kind of elections do we have? And they just shortened the time frame. That if you've got a problem, how do you get that resolved before you just say, because the law says or you're going to go to jail, I certify you.
The county judge's ruling just implies that there's no real purpose for the Board of Supervisors. If it's just they just
ministerial.
Yeah, then there's no reason to do it. Okay, that takes away the whole point of what the
So who's the gatekeeper?
What's that?
So who is the gatekeeper?
Right, that's what I'm saying. That goes against the argument, which is why I think, like we said before, we got to put this back in play in the courts. And you mentioned it earlier too. We have to go get we have to make a case to go fight this again. or get the legislature to change the statute. Yeah. That's the other option. I also agree there's nothing, and this is my opinion, we're not voting on anything here. I'm just offering my 2 cents. I agree that there's no requirement to use voting machines. I can tell you that. That's clearly may. What has occurred, though, is over the years, it has been basically become standard process to use voting machines because of the speed and the desirement of people to know who won the election. Hand counts would take a significant amount of time. And also, there is the potential, for error or fraud that occurs. Sir, this isn't open for public comment. I'm sorry. We'll give you an opportunity in the next meeting to speak. All right. So the way that is set up also causes an issue. There's no process, right? So you have to have a way to make sure there's a check and balance. I would not, and I have said this, we've talked about this, going to hand counts, but in order to go to hand counts, you have to have that process. That process has to be validated. You have to make sure there's no opportunity for fraud, that somebody doesn't have 20 votes in their back pocket and they slip in, those 20 votes, or they can play games with the tally cards and slip the tally cards in. So you have to have all these checks and balances all in place before you start doing hand counts. Somebody sent me something from Georgia. I'm trying to remember back now that
There have been a number of case studies done.
where they have developed
There are people on both sides of that issue. I understand that.
Developed a method. So if you could show a way to reasonably count votes with a high degree of accuracy that significantly limits the potential for fraud.
Well, Virginia and Missouri are two states that have done that.
Right. Then you could implement that process at the county level, and I don't think anybody could stop us if we did it.
Well, I know there's a lot more ballot provisions on there, but we did it for many, many decades.
Right. Oh yeah. A lot of
can be done.
places.
But the first issue is the law, and I'm not here to tell anyone to break the law. We have never.
No,
never,
I mean, but getting rid of the machines is possible. It's just maybe not practical right now, right? Without having that process defined. That's the conundrum, right? Is having that valid. Who is going to be the first one to stand on that cliff and leap with that process? That's the question.
Well, I would encourage the other counties to have an appropriate discussion, a productive discussion, to do that. I mean, this is our votes. This is our country.
Right.
Right?
Yeah.
It's not the government's country. It's ours.
Any questions, Mr. Rice?
No, I'd just like to thank everybody that showed up. And there is more information out there. For instance, on the county agenda website, there's a meeting if you had for February 23rd, 2023, a very thorough presentation made by Mr. LaChance. And I emailed out a lot of information that I put out in preparation for this meeting on June 19th. And I thank you, Mr. Rice, for helping us out.
And I sincerely appreciate the opportunity and the time to discuss. And hopefully I presented some information that's helpful.
Yeah. Any other comments? Ms. Gomez? No?
No, I mean, just what was I've stated before. I mean, I don't think any machines are the secure can actually be 100% correct either. And in fact, I've stated in the last election that I was in, there were a lot of issues with machines. People saw it was going crazy, and then we had to have it replaced. We had to have it fixed and replaced. And were they certified? I mean, there was just a lot that was happening, and I don't know. Hand counts, remember, like you said before, hand counts seemed to do the deal, and there wasn't. I mean, there's always going to be some cases of fraud. I know there were people that went into booths to tell people how to vote, but overall, I like the precincts. I like the hand counts. So he gave us a lot of good information to follow through, and we're going to do our best to address the issue. I just had a lot of issues with the last election, and I wouldn't have certified it or canvassed or whatever you would have called it, because there was just too many things that went wrong without people knowing about it. And I don't blame anybody who was in that process. It was a perfect storm, but yeah, there was a lot of concerns that I had about how this happened. So when we use this information moving forward,
It's a lot of information.
a lot of information.
All right, with that, we will wrap this up. The next meeting is going to be a work session on Thursday, August 14th in the hearing room to discuss Health and Social Services Department and the update on the fiscal year 25-26 budget for the Health Department. All right, that we're adjourned.